Hello, Peter.
Hi, Trevor.
Nice to see you again.
You too.
Before my memory deserts me, which it does with increasing frequency these days, can I say to, I don't think I need to say this to you or to David, but to our listeners, that we are now set up via these podcasts to, the Taxpayer is now an authorized CPD provider, which means that people can watch these podcasts, go to the Taxpayer's website, which is taxpayer.co.za, and there they can look under the Taxpayer podcast and the questionnaires. And for each of the podcasts, there's a series of five questions, which are not designed to be possibly difficult or anything like that. It's just designed to check that the person has in fact watched or listen to the podcast, and in that way you can earn half a CPD point per podcast. So why not? And we hope to improve that so that we can designate certain articles in the Taxpayer as fulfilling the same purpose, and there could be 5 questions on that article. People answer it just to show that they have actually read it. They need to get 3 out of the 5 correct, and they're not frightfully difficult. Then again, that would qualify for CPD points. Okay, enough of that. That's advertising what we hope will be a useful service to some listeners and viewers. Peter, do you want to introduce our topic for today?
Yeah, thanks, Trevor. I think we're going to talk a bit about tax disputes and aspects of tax disputes, which are interesting and relevant for, as you say, the viewers. And I think to kick off with, well, to my mind, a tax dispute starts when SARS sends you a letter asking for information. And that's generally done in terms of Section 46 of the Tax Administration Act, which deals with requests for relevant material. And it's not, as you know, Trevor, it's not one of those requests that you can say, well, I'm going to politely decline and thank you very much for your interest, but, I don't really have a response. It's kind of a statutory obligation that the taxpayer has to respond to SARS and to answer the questions. And hard to believe the Tax Administration Act's been around for 10 years. I think it was 2012 that it came into force. Oh. And Trevor, you'll remember before then, there was always a lot of discussion around, is this a fishing expedition? Are SARS entitled to ask the questions that they're asking? Why are they going back so far? Why are they asking so many questions? And I think the Tax Administration Act has taken a little bit of the zing out of the taxpayer's ability to raise questions like fishing expedition. And that's partly because the definition of relevant material is now a subjective test. So it talks about material that, in the opinion of SARS, is foreseeably relevant for the administration of a tax act. So it brings in those words, in the opinion of SARS. So it's fairly hard to sort of push back and say that I'm not going to respond because the questions are too wide, because SARS can just respond and say, well, in my subjective opinion, I need this information. Yeah. But it's not unfettered. They don't have unfettered powers in that regard, Trevor, I don't think.
No, one could always entertain a polite discussion as to why it's relevant. Relevant to what? Mm-hmm. in the nicest possible way, of course.
I think that's, I think it's exactly right. There's some other sort of interesting bits that taxpayers, I think, sometimes get wrong when they get one of these letters from SARS requesting material. And the obligation is on the taxpayer to give the information that taxpayer has. There's no positive obligation on a taxpayer to go to another taxpayer and say, I've been asked this question by SARS, I don't have the answer. Can you help me? Can you send me the material? I don't know if you've seen that, Trevor. I've often seen that. The letters addressed to a particular taxpayer, often a company or an individual, and that company or individual either has the information or doesn't have the information. And as I say, they don't need to then go to another company or another individual and say, can you help me? And, you're in a dispute environment, and you're not supposed to help your opponent too much when you're in a dispute environment, and in my sense.
Yeah. So taxpayers defined in Section 151. Is that the relevant definition?
Exactly. And you find these letters kind of go per taxpayer, so they'll address it to someone, and that someone is obviously often a public officer at a company or an individual. But as I say, you often find that particular taxpayer saying, well, I don't know the information, but don't worry, I'll get it for you. And as I say, there's no positive obligation on someone to go and get information from someone else. So you're doing SARS's work for them. They can go and ask that other person. They've got pretty wide powers, and they can go to that other person and say, here's your section 46 letter. Here's a request for relevant material. Then you must now provide it to me. So, I don't see why you should go and do SARS's work for them. And often we see that happening, and there's sort of another point that does fetter SARS's ability to ask questions. That's section 46.6. That says that SARS must ask the questions with, I think the wording, Trevor's, reasonable specificity, or words to that effect.
Yeah.
Which I think, means they need to be specific. And I think that's the point you were making earlier, that it can't be a completely irrelevant questions.
Now, I remember donkeys years ago, it was far too long ago to relevant to today. But an estate agent in Hermanus was asked by SARS for the names of all homeowners who had let out their holiday homes over the holiday season. And we politely declined that request. It didn't have sufficient specificity.
I seem to remember that somehow. I don't know if it found its ways into the court, or maybe you just told me about it. I think the other point, which is quite interesting, is pre-Tax Administration Act. If SARS asked a taxpayer questions, the taxpayer could not disclose the fact that they've been asked questions to another taxpayer under sort of tax secrecy provisions. But that's now gone. So if you get a question from SARS, you can tell someone else, hey, I got this question from SARS. And that can be quite useful for people to know, if somebody's involved in a transaction and you get a question from SARS, to be able to say, this is what I've been asked, and the other taxpayer can then think, okay, well, I need to think about my position in relation to the transaction and prepare for maybe a similar question, maybe slightly different, but, to get the heads up that SARS are investigating. Maybe it's a transaction, maybe it's a series of taxpayers, or typically a class of taxpayers. And I think that's quite an interesting sort of change from the previous regime.
Oh. Makes me think of the recent visa case in the Cape High Court, where I think various peoples were called to an inquiry and were required to give evidence in relation to a particular taxpayer. Now I think they were being required to testify. I think as persons who, sorry, I'm not too au fait with it, but as persons who might themselves be liable as interested third parties. And they said, well, that you're not allowed to rely on that testimony, and that Judge Lachranzi said they were entitled to rely on it. But I wasn't involved in the matter at all, but I'm told by someone who was that it's definitely going on appeal. So we'll wait and find out.
There's many matters that are going on appeal. We just,
Yeah,
I think pretty much everything. It's a default position. I think if you go to the tax court as sort of the court of first instance, and then it's almost a reflex reaction that you apply for leave to go straight to the SCA, and that leave, I think, is typically granted.
Yeah, as often it should be. And I mean, I got a judgment on yesterday from the SCA, which we have to take it to the Constitutional Court. I mean, with great respect, and I won't mention the case or the judge or anything. It's an appalling decision. There's some flagrant errors in it. But anyway, that's
our next podcast, Trevor, because we got to talk about that.
Yeah.
I think the one thing that I see crops up a lot with taxpayers is prescription, because I think, again, you get your questionnaire from SARS and it never stops at 3 years. I've never seen SARS say, well, we sort of on prima facie accept that prescription applies, so we're only going to ask you questions going back sort of 3 years. from the original assessment, it always goes back, I don't know, I've seen sometimes 10 years, like really, really, really long periods. And the taxpayer often says, but that's unfair because prescription applies on the face of it. And I think sort of what SARS's answer to that is prescription doesn't apply if there's been non-disclosure of material facts that if the assessor had known about at the time, they'd have assessed differently. And for SARS to work out if there has been non-disclosure of material facts, they kind of need to ask questions. So I think, taxpayers often don't realize that prescription is not a defense against questions being asked. But there is a balance there, Trevor, because at some point, people can't remember and you don't have records and people have moved on.
And that the Brumaria case, Judge Clutie in that case said, the reason why why there's a 3-year period is because memories fade, witnesses become unavailable, etc., etc. And the other thing that makes me think of, in terms of the Tax Administration Act, taxpayers are obliged to keep information for a period of 5 years. I think it's 5 years from the submission of the relevant return. And once the 5 years are up, you can toss it away. And there was a book by, I think it was an Irish book, Tax Disputes by Malloy. And he said that what makes tax law so interesting, but also quite infuriating, is that not only are you having to update your knowledge with fresh knowledge all the time, you also have to forget certain things because they're no longer relevant. You need to know what to forget and what not to forget. Which seems to suggest that some things one ought to forget, and you can't be required to edge up those old memories.
I thought there'd be an Irish element to that when you said Irish. But I think with that as well, just for taxpayers, because if SARS asks you for something that goes back 10 years and you've got it, you have to give it.
Yeah.
And if after 5 years you say, I don't need to keep this information anymore, so I'm going to get rid of it, nothing wrong with that. There's no obligation on you to retain the material longer than 5 years. But if you do retain it, and if SARS come to you after 6, 7, 8, 9, 10 years and ask you for it, and you've got it, provided it's relevant material, you need to give it. So there is something to be said for kind of taxpayers working out what information they should keep and what they shouldn't. There's a danger that, Trevor, if you give a document and nobody can talk to it, then, on the face of it, there is something there. But if you can't remember and contextualize and explain it, you might have some difficulties as a taxpayer.
But I had a client, and we've already been to court, and there's now an SCA appeal pending. It'll happen early next year. But SARS then was auditing a subsequent year, and they called for documents going way back, and this company doesn't have them. They're not obliged to keep them, and they haven't kept them. So what can you do? You have to just politely decline. So we can only do what's possible, not what's impossible.
Especially relevant early on, where SARS are trying to build a case or seeing if there is a case that the taxpayer needs to answer, and whether SARS should raise additional assessments. And if SARS don't have enough information to raise additional assessments, they can't do that.
No.
They just can't do it. And if they do it without without sufficient information, then you can take that on review, or that becomes something that you can raise in your defense, that they didn't have sufficient information to raise the additional assessment. So information is very important, and retaining and not retaining, and working out when you do and when you don't have to retain information, firstly, and secondly, provide it to SARS is really important in the dispute process. And that sort of segues quite nicely into legal privilege, because legal privilege is one of the most misunderstood concepts in the world. I think a lot of people think if a lawyer looks at something, well, it's subject to legal privilege and that's all good. But legal privilege is really, for the most part, an advice privilege. If you've given advice as a lawyer to somebody, then that's privilege, and they don't have to provide it to SARS or other people. But you need to work out firstly whether it is privileged, and advice was given in relation to that aspect, which brings you into the ambit of legal privilege. And then the second question is whether anybody waived privilege, because it's yours to waive. But if you get an opinion from Trevor or myself, and you shop it around and show it to a whole bunch of people, then you could well have waived your privilege in relation to that document. So I think privilege, Trevor, is quite a nuanced aspect and quite an important aspect.
Yeah.
often you don't want the other side to see opinions, and that's why legal privilege exists. But as I say, if often we get briefed with a whole lot of other people as well, besides the client, and you're always sort of concerned about privilege being waived up front. It's true. I think where you sit, I mean, you get briefed by attorneys. I mean, that's a lot less kind of relevant in your world, I guess. Eh?
Something that this discussion makes me think of, and I don't want to get too peripheral or distract too much, but what is the difference between a verification and an audit?
Reading a case recently?
No, indeed. Read 2 cases, and they're sort of almost exactly opposite to each other. And but since reading that case, been involved right now in a matter where SARS have performed verifications in the context of VAT, and this taxpayer is an exporter. So what they supply for VAT purposes is 0 rated. So they're always claiming refunds. And SARS then does a verification, and there's a lot of noughts at the end. SARS performs a verification, gives the taxpayer a clean bill of health, says we don't propose to make any adjustments, but then they don't pay the refund. So what we just anecdotally, we sent a letter to SARS in terms of sections 11.4 of the Tax Administration Act. Before you institute proceedings in the High Court against SARS, you've got to give them, I think it's 10 days notice. So we sent the letter. Immediately, we got a response saying, right, we're now going to perform an audit. To which our reaction was, fantastic. Please come and do it. Please come and do it as quickly as possible so we can get our refunds, because they've got nothing to fear. They've got every single document that SARS could possibly wish to see. But I'm still unclear as to what, verification is presumably where you call for, as often happens, stuff's been submitted by e-filing, and then SARS wants to see other documents to verify what it is that you submitted. When does that become an audit? If they're not happy with something, they start asking questions. Is that when it becomes an audit? I'm not sure, because there are various procedural requirements for an audit, whereas the Act doesn't talk about verifications, or not much.
Section 40 of the Tax Administration Act, it talks about verification or audit, but I think those 2 things are conflated. I don't know when a verification, as you say, turns into an audit, and the one is at least a subset of the other, you would think. They're not completely separate processes. I'm verifying something, and then I have a question. If I have a question and I'm testing you, then it sounds like I'm auditing you. So they're very close kind of concepts to me. On the edges, on the fringes. On the other end of the spectrum, you can say, I just want to verify that this is correct. Yes, it's correct. That's different to auditing you in the normal sense. But I think there is a crossover.
If they say, no, I'm not satisfied, please give me this information, then it becomes an audit, I would have thought.
It becomes an audit. That makes sense. I think we're seeing a lot of those alternative dispute type remedies, Trevor, where, in the words of the ABSA judgment, you don't want to go for the long and protracted slog to the tax courts. Instead, you go for a review or a declarator. And we're seeing a plethora of those now. We're really seeing that Forge case, the MDN case. We're involved in a whole bunch for clients as well. And I think it's really become an alternative remedy to just slogging along to the tax court and taking a number of years to get there.
I was reading some papers in the matter, and it is referred to the long and protracted slog. Now you reminded me where it comes from. It comes from ABSA.
Which is on appeal. Going to the SCA, I don't know when, but quite soon. And I think it'll be quite good. But it's quite interesting because the Ford case and the MTN case, none of them, Trevor, took issue with the ABSA principle, if I can put it that way, that of course you're free to go to the High Court, and that the High Court's jurisdiction is not ousted by the tax court. You just have to go for the right reasons and on the right basis. But I'd be astonished if the SCA in the ABSA case says you always have to follow the tax court rules and you cannot approach the the High Court, and there's too much authority to the contrary. Langholm Farms, Metcash, and other
Metcash constitutional
judgments. Yeah, so to me, that's not really contestable. I don't think it's controversial. And just for me, it turns on, if you're going to go review or declarator, it needs to be a question of law and not a question of fact. And I think you'd know better than me, Trevor, but I think the courts and judges can quickly find a factual issue and use that as a reason to send you back to the tax court. I'm being a bit cynical, but I mean, it's, I think that
but not
must be possible.
That is definitely so. Yeah. But then the High Court always has a discretion whether or not to grant a declarator. I mean, but certainly if there's a factual dispute, it's the wrong remedy.
And that makes sense. If you need to interrogate facts, then you need to stay in the tax court and you need to cross-examine witnesses, etc. But I think MTN said if the facts are clear and uncontested, then you can come for a declarator. And then it's just a question of whether the facts are clear and uncontested. In the MTN case, the court held that they weren't, that there was not a set of clear and uncontested facts. So MTN got biffed on that application for a declarator.
Yeah.
If you can save you years of slugging off to the tax court, and you've got on the face of it, it's a legal question and there's no dispute of facts, then I think a lot of clients are sort of turning to that potential remedy.
Yeah, and it creates binding precedent on other taxpayers, whereas a tax court decision doesn't. So it's useful in that sense as well.
That's true.
Yeah.
And it's named. But clients don't really care about that. The secrecy provisions in the tax court. I mean, clients, I haven't seen clients really care about that. They said, look, we believe in our case. What do we've got nothing to hide. We can go to the High Court and get named there, and so what? So,
I mean, the secrecy is temporary anyway. If you take it, as we were saying earlier, so many cases are taken further, then that evaporates.
That's true. Yeah, that's absolutely right. So I think as I say, we're in a new world of these alternative remedies, and we're certainly seeing a lot of those come up, which I think is positive for our law and for tax law in particular, that you don't have to feel that you're sort of stuck in this tax court process. And Trevor, we've spoken about it before, suspension of payment, because tax disputes is one of those rare cases where you hand over your cash very early on at the at the assessment stage, so you're out of pocket for years potentially. So
So I mean, to sort of pull it together, and I'm not trying to conclude anything, but one's got to have a sense of what is the right remedy for whatever it is. What is one setting out to achieve, and what's the best way of arriving at that result.
I think that's right. And going for review or declarator doesn't shut the door on the tax court process as well. If you get turned down in terms of your review application, you can carry on with your objection and slog along to the tax court. So it's not sort of binary. You just have to watch the timelines and SARS. In some cases, SARS have been quite happy to suspend the tax court process, but in some cases they're not, and you need to run this sort of parallel process, which is not ideal for a number of reasons. But certainly going for review doesn't mean that you can't go to the tax court, which I think is quite nice as well.
I was involved in one review, and I mean, you have to bring the review within 180 days after the action that you want reviewed. But you also have to exhaust your internal remedies. And the judge in question, this was in the High Court, Judge Pitt's ward, he said that objection and appeal are part of your internal remedies. You've got to go that route first before you come to the High Court for a review. I'm not sure if that's necessarily correct.
It's because you have that internal remedy hurdle that they impose on you statutorily. So
Yeah.
I think in the Emslie case, they went Padja, but they also went principle of legality, which is sort of common law outside of Padja. So I think they sort of hedged their bets, and I think that might have been because of the internal remedy point.
Yeah. That's the requirement of Padja, isn't it? Yeah.
Yeah, so I think you need to, Trevor, I think 100%, because SARS will always raise the point that there are internal remedies and you need to follow those. And I think you need to have a decent argument around why going to the tax court is not an appropriate internal remedy. And then, as I say, you can go principle of legality as well. And then a declarant is not brought under Padja. So I think that you don't have that particular hurdle. So, but there's a lot of decision making.
Oh, I asked a friend and colleague if he would write something about the distinction between a legality review and a Padja review. I mean, I've got a feel for it, but something really precise and something you can read and reread, and I'm still waiting for it.
I was going to say, send it my way. I'm very interested to see that when and if it arrives. Trevor, we can put it in the taxpayer.
Well, indeed, that was the whole idea. In it will go as soon as it manifests.
Very good, very interesting, Trevor. Always good chatting about these things.
And as far as timelines are concerned, is it, in your experience, does it take longer to get a matter heard in the tax court than if you can, say, for example, go for a declaratory order in the High Court, which is quicker?
Much longer to go to tax court, because you got all the sort of the pleading stages, and it just takes forever, and then discovery, and it just drags on for years. Whereas review can be pretty quick because you've got your 3 affidavits, founding, answering, and potentially replying. And then it takes a bit of time to get a court date, but in Cape Town, we found probably around 6 months, which is not dreadful, and a bit longer up in Pretoria. But you can be in court within sort of 8 to 8 months of starting your review, as opposed to many years in the tax court. So that's a significant advantage.
Oh. And one's got to be so careful in doing the rule for the taxpayer, the Rule 32 statement, which is your pleading.
Mm-hmm.
I mean, in the recent Capitec case, a VAT case, they claimed a section 16(3)(c) deduction, which is different to input tax, although the court referred to it as input tax. It's where an insurer makes an indemnity payment, you can deduct the tax fraction of that payment. They claimed a full amount, and they hadn't pleaded apportionment. And the court then said, because I would have thought there was an obvious case for an apportionment at the very least. And the court said, yeah, but you haven't pleaded it, so we can't consider it. And that makes me think of what I thought was a brilliant judgment by acting Judge Kun in the Africa Cash and Carry case, where he said, pleadings are there for the court, not the court for pleadings. So that provided fairness has been observed and the parties have had every opportunity to advance whatever case they want, then the court does not have to be hidebound by the pleadings. Of course, one can't rely on that too much, and certainly in Capitec, I would have thought if you've claimed something as a deduction, the court could well say, okay, I'm not going to give you everything, but I'm going to give you an apportionment. But the court just said, no, you hadn't pleaded it, so I'm not even going to consider it. It strikes me to be a bit high.
Yeah, because courts are unpredictable, Trevor. So that's, yeah. But I think we've talked long enough, Trevor, as much as I've enjoyed it. And I think we should save the rest for next time. So
okay.
Good seeing you. And
we won't sort of flip a coin or anything like that to determine. Sometimes gets the feeling that's how cases are decided, which makes a mockery of the whole process. Yeah. And really, I mean, when we don't like to see our professional discipline mocked in that way, but really you're dealing with human beings, and you can never predict what the outcome is going to be. So one needs to be very cautious and sensible. And that applies equally to choosing the appropriate remedies and, you know, having a fallback position and all of that. Peter, nice to see you again. And we'll keep trying to churn out the CPD points. In the most convenient and cheap, indeed gratis manner.